Hey folks, James Abrenio coming to you from Abrenio Law, your Northern Virginia personal injury and criminal defense law firm. So you want to know what a non-suit is. You've talked to your attorney, you've heard it on the internet, you've read it on Google, you've heard about this non-suit thing, or you're in a situation where you've got a trial date coming up and you're running out of time and you don't know what to do. Under Virginia law, there's something called a non-suit. What non-suit is essentially it's a voluntary dismissal of your case that allows you to drop your personal injury case, your Virginia car accident case, and then within 6 months refile it. You essentially get a redo. Oftentimes, non-suits are important when it comes to certain aspects. Let's say, for instance, you've got a trial coming up and you depended on your expert witness to be there. They told you they're going to be there at trial or a deposition, and all of a sudden they are no longer to be seen. They don't show up and you're in trouble. Let's say your expert witness has told you that they believe that your accident has caused your accident injuries and they're willing to testify to that. Everything is set up. You're close to trial. They've already been designated as a witness, and all of a sudden they've changed their mind and they don't want to be involved. A non-suit can offer you an opportunity to essentially take another stab at it. And it allows situations where if ordinarily, if let's say you were in federal court where there's no non-suit, you would essentially be out of luck and you couldn't proceed with your case. So a non-suit is certainly a very important aspect of Virginia car accident and personal injury law that allows the plaintiff a really good avenue if things don't go well. Now, people ask me, well, James, would non-suiting hurt my case? Why should I non-suit versus what are the downsides of non-suiting? This is a very complex question, and it really is going to depend on the details of your case, and every case is different. But generally speaking, the downsides of a non-suit are kind of common sense. Number one is you're going to have to refile, and if you're in circuit court, for instance, and you've probably already waited for a trial date for years or a year or more, when you refile, you're going to have to restart that clock. So it's essentially restarting the wheel, and it takes time and effort and stress to redo that. So I typically don't want to take a non-suit unless I'm in a situation where I have absolutely no alternative. My expert witnesses backed out on me, of key vital witnesses backed out on me, or there's some other aspect of the case that I need another redo. I need to stop it and then start again. I've had certain situations where witnesses or my clients will just, I've had a few cases where somebody's hired me, client won't get back to me, and we've missed deadlines, and they finally get back to me. And the only way I can essentially save their case is the non-suit, which fortunately in the past I've had that. So another rule: keep in touch with your attorney if somebody's representing you. Don't just peace out on them because you're only hurting yourself. Another aspect of non-suiting is you've got to do all the other legwork that you had. Leading up to trials, there are certain reports that need to be filed. There's witness lists and exhibit lists that you have to be filed. You have to do trial prep, and you have to have everybody scheduled to be at trial. And redoing that can be a real headache. So you don't want to be in a position where you have to redo it. The other thing is my concern is always that a defense attorney sees that as a sign of weakness. If they force me to take a non-suit, or I'm in a situation where I take a non-suit and they don't even know why, they're thinking, goodness gracious, I wonder what's going on over there. Maybe there's something that's going to end up hurting their ability to prosecute the case, and they've now shown their hand by having to take a non-suit. Now, that being said, taking a non-suit and having the opportunity to refile can obviously be a great thing when you're in certain situations. So I would rather take a non-suit and refile and still preserve the claim rather than just being worried about what the non-suit is going to do to my case and not refile it. So if you're facing a non-suit, just be aware that it's something that you really need to talk to your attorney about, and you're going to have to make that decision and determine what's the best case for you all, and it's got to be made intelligently. There are other aspects that make the non-suit a little bit more complicated. For instance, you can't take a non-suit if there's a cross-claim and other technical rules, but your attorney should be talking to you about that when you're considering a non-suit. So hopefully this answers your question. Wish you the best of luck. Feel free to reach out to us, www.abreniolaw.com. You can also give us a call, phone number 703-570-4180. Wish you the best. Thanks.